Our last topic in this chapter is leaving prison. So the question is, what is parole? Parole is the supervised early release of inmates from correctional confinement. It is a strategy of prisoner reentry into the community from prison that differs from probation in both purpose and implementation. Whereas probationers generally avoid serving time in prison, parolees have already been incarcerated. Whereas probation is a sentencing option available to the judge who determines the form that probation will take. Parole results from an administrative decision by a legally designed paroling authority. Probation is a sentencing strategy. Parole is a correctional strategy whose primary purpose is to return offenders gradually to productive lives. By making early release possible, parole can also act as a stimulus for positive behavioral change. Parole was a much heralded tool of the 19th century corrections. Its advocates had been looking for a behavioral incentive to motivate youthful offenders to reform. Parole, through its promise of earned early release, seemed the ideal innovation. The use of parole in this country began with New York's Elmira Reformatory in 1876. Indeterminate sentences were then a key part of the rehabilitation philosophy, and it does remain so today. States differ as to the type of parole decision-making mechanism they use, as well as the level at which it operates. There's two major models that prevail. Parole boards. State paroling authorities grant parole based on a board member's judgment and assessment, and their release decisions are termed discretionary parole. And two, statutory decrees produce mandatory release, with release dates usually set near the completion of the inmate's prison sentence, minus time off for good behavior and other special considerations. 15 states have entirely abolished discretionary release from prison by a parole board for all offenders. Another 5 states have abolished discretionary release for those who commit certain violent offenses and other crimes against persons. Some states, such as Alabama, have abandoned traditional parole but grant the parole boards the authority to revoke the post-release supervision status of offenders who violate release conditions, ordering them to return to custody. As a result of the movement away from release by parole boards, statutory release, usually involving a brief mandatory period of post-release supervision, has become the most common method of release from prison. In New York, we have kind of a combination. We do have parole boards. We have an intermediate, indeterminate sentencing. And during those periods of the time, if you remember, in indeterminate sentence, 1 to 3 years in prison, there's a range. When they hit their minimum, which would be 1 year, generally, an inmate gets to see the parole board to determine whether or not they could be released, discretionary release. Then we have the time, the good time off from behavior, to allow people to integrate into parole. They'll hit a certain point, their conditional release date, as they call it, where they'll be released to parole and then be supervised for the remainder of their time. And then with our determinate sentences in New York State, there's a mandatory provision for, they call it post-release supervision. It's parole. It's the same concept. It just has a different name. So somebody who was sentenced to a determinate sentence, like 4 years flat, the statute will also say that the court has to add a component of post-release supervision, which is usually a range. One to at the maximum is 5 years, and the minimum is 1, but it depends on the crime. So that's how it works in New York. The next question is there a legal right to parole? What happens if the parole authority denies early release, but an inmate believes he is deserving of parole. Perhaps he has witnessed other inmates receiving parole who have similar institutional records. Can he question the parole board's decision via the courts? The Supreme Court answered this question in 2011 when it ruled in the consolidated cases of Swarthout versus Cook and Cate versus Clay that due process requirements are satisfied when a prisoner has an opportunity to be heard and is provided a statement of the reasons why parole is denied. There is, in essence, no absolute or legal right to receiving parole. The first case, the Cook case, involved Damon Cook, who was incarcerated in California for attempted first-degree murder. In 2002, the California Board of Prison Terms rejected his parole request. California law provides that if the board denies parole, the prisoner can seek judicial review. Subsequently, the California Supreme Court, the California Court of Appeals, and the California Supreme Court all denied Cook's petitions, prompting him to seek federal assistance. That's that whole, you need to go through and exhaust your administrative remedies. That's the process, and now you get to go to federal court. Same thing with the Cate versus Clay case that began with the 1978 conviction of Elijah Clay for first-degree murder. In 2003, the board found Clay suitable for parole, but the governor reviewed the case and found Clay was unsuitable for parole. So in that state, in that instance, the governor got to trump the parole board for release. So after going through the state process, exhausting his administrative remedies, Clay filed a claim in federal court. The district court concluded that the governor's reliance on the nature of Clay's original offense rather than his prison behavior violated his right to due process. The appellate court, because that got appealed up to the next court, the Ninth Circuit, concluded that the governor's decision was unreasonable. Again, the cases both went up to Supreme Court, and the Supreme Court said, whoa, hang on, federal courts, you can't get involved. What they said, their decisions, they held that the Due Process Clause requires only fair procedures in parole hearings. However, it held that both Cook and Clay received adequate process because they were allowed an opportunity to be heard and were provided a statement of the reasons why parole was denied. The courts do not have the right to step in and conclude the parole board and the governor's decisions were faulty. If the process is fair, then the inmate must live with the outcome. So basically what the Supreme Court said is, federal courts, we don't get involved. Let them decide, and then if the only reviewing issue is if whether or not they were afforded a fair process during the parole release process. So they had a right to be heard, they had a hearing, they appealed in state court, and so forth. After that, there isn't multiple attempts. So as long as they are afforded their rights at the time of the parole hearing, then the decision, which is discretionary, stands. So that is there a legal right to parole? And now our next question we are going to talk about is success. Is it effective? How successful was parole? And despite all efforts to treat, correct, and rehabilitate incarcerated offenders, a majority still return to prison shortly after their release. An important federally sponsored study of more than 270,000 prisoners released in 15 states found that within 3 years of release, 2/3 of parolees were rearrested. Half were reconvicted, and about 25% resentenced to prison. So in all, more than half of those released are back in prison, serving time for a new prison sentence, or in some cases, a technical violation of their release. A technical violation would be such as failing a drug test or missing an appointment with the parole officer or being, arrested for a new crime, or even a curfew violation. Another study, similar study of about 300,000 parole discharges found that more than half either absconded or returned to jail or prison. Absconded means, in parole terms, they stop showing up to parole or meeting with their parole officer. They skip out. These data show that most offenders fail upon reentry into the community, and failure is most likely to take place soon after release. One Bureau of Justice Statistics study examined 5-year post-release offending patterns of people released from prison in 30 states beginning in 2005. The study used different measures to determine reoffending, including a new arrest, court adjudication, conviction, and incarceration for either a new sentence or a technical violation. It also documented the extent to which the releasee prisoners committed crimes in states other than the one in which they were released. Not unlike the other studies, this most recent one found that about 2/3, 60%, of released prisoners were arrested for a new crime within 3 years, and 3/4, 76%, were arrested within 5 years. Within 5 years of release, 82% of property offenders, 77% of drug offenders, 74% of public order offenders, and 71% of violent offenders were arrested for a new crime. Young inmates were more likely to fail than older ones. Within 5 years of release, 84% of inmates who were age 24 or younger at release were arrested, compared to 79% of inmates ages 25 to 39 and 69% for those age 40 or older. Interestingly, not all states had the same failure rates. It seems as though parole was successful in states that employed programs that targeted motivated offenders to stay crime and drug free through the use of sanctions for violations and rewards for obeying. Let's talk about supervision. Once out of prison, inmates they no longer are an inmate, they become a parolee, who is then supervised by a parole officer. Kind of similar to a probation officer probation, as I explained, probation and parole are different, but the officers have similar duties. Parole officers may be either focused on social work or rules, follow the rules, or a combination of the two. They are responsible for not only monitoring the parolee, but also ensures parolee abides by the terms and conditions of their release, which is set forth by corrections, not by a court. If they don't abide by the rules, they will be subject to a violation. The violation is filed by the parole officer, and then there will be a hearing before a judge to determine whether or not to revoke their release and send them back to prison. Sadly, when POs are backlogged, they have lots of files, lots of parolees, they tend to lean towards more the traditional follow the rules. If you don't follow the rules, I'm going to violate you, and you just go back to prison. When they have so many folks that they're dealing with, sadly. So that's generally how the supervision works. Let's talk about problems with reentry. Besides the separation from family and friends that an inmate suffers, or the psychological problems and the fact that they lack skills, ex-inmates particularly find that going straight is an economic impossibility. It is particularly difficult in the present job market with so many out of work. Many employers are reluctant to hire an employee or people who have served time. Even if a criminal record does not automatically prohibit all chance of employment, why would an employer hire an ex-con when other applicants are available? If they lie about their prison experience and are later found out, ex-offenders will be dismissed for misrepresentation. Research shows that former inmates who gain and keep meaningful employment are more likely to succeed on parole than those who are underemployed or unemployed. One reason that ex-inmates find it so difficult to make it on the outside is the legal restrictions that they are forced to endure. These may include bans on certain kinds of employment, limits on obtaining license, and restrictions on their freedom of movement. One survey found that a significant number of states still restrict the activities of former felons. In general, states have placed greater restrictions on former felons as part of a get tough movement. These have been described as invisible punishments that reduce the rights and privileges of those convicted of crimes. Only recently have initiatives become more widespread to reduce not only the social stigma associated with criminal convictions and incarceration, but also to reduce the likelihood of subsequent offending. So why do people fail on parole? Well, parole failure then is still a significant problem, and hundreds of thousands of people in correctional population fail on the outside each year. Some reasons, well, I just discussed them, the same reasons, just prior economic issues. The very nature of the prison experience itself may be a factor. The psychological and economic problems that lead offenders to reoffend are rarely addressed by a stay in prison. Once released from prison, offenders face a multitude of difficulties. They remain largely undereducated, unskilled, and usually without solid family support systems. When they return to society, it may be the same destructive neighborhood and social groups that prompted the original law-violating behavior. It is also possible that parole failure is tied to the releasee's own lifelong deficits. Most research efforts indicate that a long history of criminal behavior and antisocial personality and childhood experiences with family dysfunction are all correlated with post-release reoffending. Reoffending may be a byproduct of the disruptive effect a prison experience has on their personal relationships. Ex-inmates may find their home life torn and disrupted when they are finally released. Wives of inmates report that they have to face the shame and stigma of having an incarcerated spouse while withstanding a barrage of calls from their jealous husbands on the inside who try to monitor their behavior and control their lives. Family visits to the inmate become traumatic and strain relationships because they often involve strip searches and other invasions of privacy. Sensitive to these problems, some states have instituted support groups designed to help inmates' families adjust to their loneliness and despair. Another reason why parolees fail on parole is because the increase in the numbers of those on parole led to a change in the type of service provided. This is what I mentioned earlier as well. Parole supervision went from a service type where the officers attempted to help each individual to a surveillance type of work where officers try to catch parolees committing violations to send them back to prison. A part of this change is that the dramatic increase of those on parole meant that parole officers had large caseloads and lacked the time to have an individual approach to parolees. An individualist approach is needed to place parolees into programs that are more suited to their needs and can more effectively prepare them for their future within society. Okay. What's our next question here? How can changes on reentry be improved? Chances on reentry be improved? What can be done to improve parole's effectiveness? Let me tell you about Jeffrey, an ex-offender. This is what he has to say about adjusting to the outside. I think the hardest thing about coming out of prison to the free world is finding a job. I was born with 2 strikes, being black and male. Then once a man gets a criminal record, that is a 3rd strike. They say they want you to make it, but everywhere you go, state agency, job interview, with private employer, you are met with the same look. It is the look that says you're unwanted, and no matter how many help wanted signs are in the windows, it always seems they want everybody's help but mine. What makes it even more difficult is that while we were in prison, we gained very few viable skills, nothing that can really help you in society, so that when you get out, most of us are unequipped to make it. One way of improving parole effectiveness is to analyze the factors that predict parole success or failure, and then build programs around those results. A number of attempts have been made to isolate these factors. In one such attempt, a group conducted a large-scale study to examine the employability of ex-offenders and prisoners. They found that aside from those with an intellectual or psychiatric disability, those with a criminal background were deemed less likely than other disadvantaged groups to obtain and maintain employment. They found that 6 broad domains influence the integration of ex-offenders. Those were, I think these are in the book too, personal conditions, rehabilitation and counseling support, employment and training support, social network and environment, accommodation, and the criminal justice system. Another similar approach or study by Supervision and Jeremy Travis found that repeat offending is affected by several factors. Personal and situational characteristics, including peers, family, community, and state-level policies. 2, incarceration experiences, and 3, the period after release. It may be possible to create effective parole programs built around these criteria. We will hopefully see that in play. Take a moment to talk about the Second Chance Act. On April 9th, 2008, President George W. Bush signed the Second Chance Act into law. Receiving bipartisan support in both chambers of the Congress, the bill was supported by a broad spectrum of leaders representing law enforcement, corrections, the courts, and local government. This first-of-its-kind legislation authorizes various grants to government agencies and nonprofit groups to provide employment assistance, substance abuse treatment, housing, family programming, mentoring, victim support, and other services that can help reduce reoffending and violations of probation and parole. If properly financed and carried out, the act could cut the reoffending rate and the horrible prison costs for states by helping them develop programs that former inmates need to build viable, crime-free lives. The Second Chance Act provides millions of dollars in funding to study these topics as smart probation projects, treatment of returning adults and juveniles with co-occurring substance abuse and mental health disorders, adult and juvenile reentry demonstration projects, adult mentoring programs, technology career training projects for incarcerated adults and juveniles, and demonstration field experiments to test parole reentry models. So that has been, haven't seen much research on how that money was spent since 2008. Now it's been 12 years. Having fewer prisoners might improve reentry. Developing post-release programs might even be more effective if the size of the correctional system was reduced and fewer inmates held behind bars. Greater parole and aftercare resources could then be targeted to a smaller number of inmates returning to society. But would a reduced emphasis on incarceration produce a higher crime rate? Something nobody really wants, right? But not according to a 2014 study that was conducted by the Sentencing Project that examined prison population reduction efforts in New York, New Jersey, and California. Each has reduced its prison population by 25% during the past decade, at a time when the nationwide state prison population rose by 10%. While downsizing their prisons, these states experienced the violent crime rate falling at a higher rate than it did nationwide. Property crime rates also decreased in all three. If prison populations can be reduced by 25% with little or no adverse effect on the crime rate, then the savings could be directed at helping those being released from prison to achieve better results in the community. The fact that fewer parolees are being returned to prison each year is a positive development in the goal of prison population reduction. In New York is working on an entire parole reform. And one of the key components is that a parolee who is violated for a technical violation, i.e. they missed an appointment with the probation officer, they missed their curfew deadline of being home because they're on GPS monitoring, failed a drug test, that you don't go, it's not an automatic trip back to prison as a result after they go through the hearing. So that's just one of the components, but they have several excellent components that they're trying to reform and put forward. And so on that note, this concludes chapter 12, and it also concludes the materials for the semester.